All right. Good evening once again, and thank you for joining. Welcome you today, and I'm happy. Today's session is about protecting your intellectual property, and I'm happy for some of the exciting news that we've been hearing from all the members of the cohort. Altogether, for now, we have been able to register or incorporate about 5 businesses from everyone who is currently in the cohort. Of the 5 businesses that were registered, we have seen about three. I believe Marian Miller LLC has opened a bank account as of now. Jade Matthews now has 2 bank accounts, and Jade Matthews now has 2 bank accounts. We have registered Matterhorn. We probably will get update as we come along, and then we also have Liz. What's Mrs. Olayinka's business now? Lily Beth. Lily Beth was also incorporated over the last week. So great news as we go along. I'm very happy with what I'm hearing. But today we're going to be talking about protecting your intellectual property, and we're going to touch on it. There are about 3 categories of places that I would like us to touch on when it comes to protecting intellectual property. And before we get in there, I'll just run you through what we want to talk about: introduction to intellectual property, patents, copyright, trademarks, and the cost of having any of this done. And intellectual property is basically a means of protecting the reuse or the protecting the result of innovation and creative activity. And what that simply means in layman terms is, if you are an inventor, and what that means is that you came up with some certain products, and or you invented something. Now, in order for that particular invention not to be adulterated or taken advantage of by any other person, there are ways by which you can protect that invention from adulteration, and it's very key when it comes to some key things that we call invention. A lot of time, as we usually say, we say we're not trying to say you should reinvent the wheel, but oftentimes we see people come up with some products that will be your own engine out of your own ingenuity, that okay, well, I've seen this thing done this way, I've seen this thing done this way, but I actually want to be able to do this thing my own way. I'll take this idea from this place, I'll take this idea from this place, I merge it into one, I'm able to create my own product, and then I'm good to go. Now, when you create that kind of invention, it means you have a right to it. Otherwise, if you do not patent that kind of invention, it means that it's free for all. Any other person can see the same invention, decide to go replicate it, and put their name on it. As long as there's no patenting to protect that invention, unfortunately, it's not just yours. Now, intellectual property rights, IP rights, or intellectual property rights are territorial. And when I say territorial, what it means is that you are able to lay claim on that particular invention. And of course, intangible assets, which can be bought or sold or licensed. So, for instance, you can see, you hear about franchising, right? And some franchises requires that you patent them so that people just don't go and recreate it. So for instance, you cannot just wake up one morning and say you want to go and start a McDonald's restaurant. Same way, you cannot wake up one day and say you want to go and start a Starbucks coffee shop. Now, those are patents, franchises that you need a license to be able to operate it. And you cannot just say, oh, because just like the way they make money in the Starbucks shop, you want to go and start your own. You will be infringing on the rights of the person who owns that patented or that intellectual property. And that's why the law allows you to be able to protect your own invention. Okay. So now there are about 5 or 6 ways by which you can protect intellectual property. But for the purpose of this session today, we're only going to be talking about 3 of them. And these 3 of them are actually as it pertains to small businesses, large businesses, and all of that. And we talk about patents, we talk about copyright, we talk about trademarks. And of course, the next question someone will ask me is, how can I protect my own intellectual property? Or how can I avoid infringing on the rights of others? So now, when you have an invention and you patent it, it means you have a right to that intellectual property. Now, if someone out of their own thinking decides to replicate that invention without express authority from you, that is what we call an infringement. It means that they are infringing on your right to own that invention, and it is punishable by law. And that's why there's an agency within the United States and even all countries. They have an agency that is responsible for managing the process of registering a patent, trademarks, or copyright. Okay. So why do I need to protect intellectual property? One, you want to stop others from using what you've created, like a brand, a product, or a process without your permission. You want to be able to generate income by licensing. You want to be attractive to investors. And of course, possible to arrange for intellectual property valuation and borrowing against intellectual property rights. So I'm going to take 1 or 2 of this. I've already mentioned that one of the reasons why you protect your intellectual property is to stop others from using it, which means you are putting it in place so that people will not infringe on your invention. Another way or one other reason why you protect an intellectual property is to generate income through licensing. And that's where franchising comes in. Now, and there are so many franchises that is going on right now. We have Great Clips. It's where they make here or cut here. McDonald's gives licenses. Starbucks gives franchising. Chick-fil-A. Almost all of these food outlets have been able to protect that intellectual property to the extent that they are only able to be replicated through licensing, which is called franchising. And of course, apart from franchising, some people will give you license to be able to work their product. So for instance, a typical Microsoft has patented Office, their Office tool, in such a way that it is their own product. They have protected it by law using the patenting, and anyone who is going to use Microsoft Office on their laptop today in this world that we are needs a license in order for you to be able to use it. The moment you are trying to cut corners to be able to use a Microsoft Office fraudulently, you will always get pop-ups that tells you that you are not allowed to use this. And that's the way it is when it comes to protecting your intellectual property. And of course, by the time investors are looking for organizations that they can buy out or they can partner with or they want to invest in, they are looking at, okay, how is this person or how has this company protected themselves? Or how can we, so how are they protected themselves? Because if we invest money into this, what stops another individual or another person tomorrow to start up another business and begin to do the kind of things that they do? So as an investor, these are some of the things that they look out for. Okay, I want to invest in this company. What makes it different from the other company out there? What makes this one different from their competitors? And these are some of the things that they investors are looking at, okay, this intellectual property is protected from adulteration or infringement, and then they are good to go when it comes to that. So let's talk about patents and what is patent. Patent is a right protecting an invention. The deal. A patent affords a territorial privilege or monopoly for a limited period, usually about 20 years, in exchange for letting the world use your invention after monopoly expires. Maximum duration of 20 years in most countries, and it's the same thing in the United States. So, can you, anyone, hey Ruth, thanks for joining, tell me what you consider an invention in any of these three images that you're seeing here? Why do you think they are inventions, or what do you think that they are doing? What is the use of any of these products?
They are used, all these products, okay, they are used in the kitchen or for eating or for dining. Yes. Except for this last one, I'm not sure what it is. The box at first, I don't know what that is. Good evening, everybody. Sorry for coming in.
That's okay. Thanks for joining. Yep.
I think the first one is like a soap stacker, right? So you put your bar soap and for storage. Yeah.
So all these items are stuff we can. This first one is a soap stacker, so you can use it in the kitchen. The second one, the spoons, it's like a pen cover, but it can also be used as cutlery, so you don't have to buy cutlery while you're maybe in the office or something like that, and it can be personalized. And then the third one is a bread knife. I think, yes, it's a bread knife. And then it has like a suction table where you can wait as you're cutting the bread. It's not spilling all over. It's been suctioned out or something like that. I think that's what that invention is meant to be.
Yep, great thought. So in actual fact, the third one is a breadcrumb. Breadcrumb, how do I say it? Should we call it a catcher or a breadcrumb storage? Whereby if you see that there are holes on that wood, and right underneath it, there's a kind of a funnel that is almost all underneath all the holes, and any breadcrumb that you do or that you have from cotton bread, and it's not just breadcrumb, any kind of crumb that goes directly from there into that small pocket, after which you can then detach and throw in the dustbin. Now, these are all someone's doing an invention. Look at the Din ink. Dine ink is the name of this, or you can call it Din ink. So which means while you are writing, you can use it for your food, right? All you just need to do is make sure you have a pen and you stick the pen into it, and then it becomes your silverware to be able to eat. Someone thought about that. Now, the soap stacker, you find it interesting that the inventor of this product is Tony Akinpade, who happens to be my brother, who lives in Georgia. It came up with this idea of and this is the way invention comes about. Your personal experience usually helps you think outside the box. You know, a lot of times back in the days, maybe before we came into the United States, you find yourself using bar soaps or key soaps, and you'll notice that only after that soap finishes, you'll probably be in the bathtub when you realize that you need to take another one. And at that time, you already have water on you, then it means you have to get out of the bath wet and all of that. But it came up with this idea that says, okay, you can have as many as 3 to 4 bar soaps within your bathtub area. And all you just need to do is get some kind of device or some kind of container that will be neatly stuck on the wall somewhere near the bath where you can take it or stack it. And of course, by the time you take the one on the, by the time you take the, you can see the last one. By the time you take it, all you just need to do is remove a slider that brings the third, the second one onto the last. Just an easy way for you to stack your soap. And if when I was talking to him, it was the one that first introduced, not that he introduced, I've heard about patenting before, but he was the first person that went through the process of patenting to let you know that this is what it needs to do, what you need to do when you come up with an invention. And another thing is this though, before you call it an invention, it means that it's not been there before. Because if it's been there before, yep, it could be considered an adulteration, or you are just doing something different than what. So for instance, if you create something like this and then you decide to make yours maybe silver or maybe steel, aluminum, stainless steel, it doesn't make it an invention. You are just replicating what has been there already. But in order for you to get an invention into the books, they must know that truly there has not been anything like this before. And by the time he came up with this idea, there has never been anything like a soap stacker prior to now. I don't know after then, but prior to the time that he did this product, there has not been anything called a soap stacker. And that's what intellectual property means, and that's how you protect your property. So this is about patent. Now, what can you get a patent for? You are able to get a patent for inventions related to products, and that's one of the things that we saw in the last slide, methods or manufacturing processes, or other aspects of new technology used to solve a technical problem. One, I mentioned it, it must be new. That is, it has not been published anywhere else before, including by the inventor or the owner. So which means you can't come and tell me that this is a new invention if you have done it in the United States. So my brother now, who has this soap stacker registered as a patent in the United States, cannot go to the UK and claim that this is a new invention again. No, it's no longer a new invention. It has to be new, the first and the ever, to be considered an invention, and at the same time for you to be able to record it as or register it as a patented product. And of course, it must involve an inventive step, non-obvious to everybody or non-obvious to a person skilled in the art. So for instance, you want to call it an invention, right? How is opening, how do I, what can I think about? So hand fans. Hand fan came about 3 to 4 years ago. Nobody even knew that it's possible that you have a handheld fan that people are using at parties right now or in churches and stuff like that. It's not even a souvenir that people are buying everywhere now. Now, someone thought about that. I hope that person pretended it, because if they did not, they have just lost a whole lot of business. However, if that product already exists and then you were trying to recreate it, and it doesn't involve anything beyond the fact that you created it the way the real inventor created that product, you have not done anything different. There must be some kind of inventive step to it, which means, so someone created the telephone. Someone created the telephone from the rotary to the mobile. That's a major step, because in the days of the rotary telephone, it has to be stationary. It has to be in the living room. It has to be in either a bedroom or somewhere. The best you could do is have one in the living room, have one in daddy's room, have one in mommy's room. But at the time that you are using that phone, you are stuck in that location where it is. However, when it came to mobile, people are now able to move around with their mobile device and still be able to achieve exactly the same thing they achieved, or even more, when they were using the rotary phone, except that now you can be mobile, you can move from one place to another and you are good on still on that call. So as I rightly said, you must, whatever you call an invention must have an inventive step involved in it. And it has to be clearly defined, showing that truly I created this process, or I created this product, or I created this method of doing things differently. What can you not get a patent for? The law provides a list of things which are not limited to the things I listed here, excluded from patent protection, which are: you cannot patent a product, computer program, you cannot patent a business method, a mathematical method, methods of performing mental acts, methods of playing games, presentation of information. You can't patent any of those. And the list is inexhaustive, but it just shows you that in order for you to be able to get something approved as patented, there's a lot of work that goes into it. There's a lot of work that goes into it. In actual fact, it takes up to about 36 months for you to get an approval for a patent. And we'll still get to that in a couple of minutes, just to let you know that you have to publish it. It must be in a publication for up to about 30 to 45 days, just so that it will be out there for someone to say, no, this cannot be a patent because I've done it before, or I know someone who has done it before. So it's a test of viability when you decide to come out and say, I want to patent this idea, or I want to patent this product. So look at the timeline for patenting. You can see it takes about 48 months, which is about 12, 24, 36, 48. That's about 4 years. A good 4 years for your application to be granted. Now, the moment you come out and say you want to patent something, there's a first filing. After 12 months, file priority claiming application. 24 months, request examination can be requested earlier if you choose. Then the length of time that allows for people to be able to debunk it is between 24 to 48 months, after which, if nobody comes out, they approve it for you for the next 20 years. Now, I mentioned this to you earlier. I'm not sure whether Ruth was here by that time. Your patent can only be for a period of 20 years. After 20 years, you do no longer have the monopoly of right to that product any longer.
Yes, I got it.
Thank you. So you can now begin to appreciate what is involved in patenting a product. Now, a few things to note. Be very careful about disclosing your invention prior to filing. If you have an invention, you have to be very, very careful, because as long as that product has not been patented, if you launch it, then you do not have a right to it any longer if anyone goes into it immediately. Because the only reason why you can lay claim to it is if you have a document that says this product has been patented for Isaac and Philip Consulting. Otherwise, you do not have a claim on it. And of course, if you are in doubt at any point in time, you want to speak to a consultant or a patent attorney who can help you figure out truly, is this something I can call my own? And you will begin to find out, Jade, in the line of business that you're doing, and even Ruth, you will find out that ideas will come to you that will come natural, that, okay, if I'm placing an order for this from China, is it possible that I ask them to create my own specific for me by me? Those kind of things will come. And if at the time you get to that level and realize that, wow, this is just my idea, have you seen it anywhere? You look far and wide. Has anyone ever done this product before? Same thing with Ruth. You could come 2 years down the line, 3 years down the line, and then you decide to come up with a spice that people can use to grill. This spice is your idea, no one else. Every other person can create a spice. I don't care. But this, my own mama recipe, is for me, by me, and for the world to use. Those are some of the things that you can decide to patent or trademark, just so that you have a right to it while you create it, because it's your invention. So, and whenever that time comes, you want to make sure that you realize that, okay, has this been done by anyone else before? If it has been done by anyone else before, that's fine. You can just create a and move on. But if it hasn't been done by anyone else before, you want to try and look into patenting that idea, because it might be your ticket to wealth. Because if and when you do that, trust me, you will attract people who wants to do the same. And when you attract people who want to do the same, it's either they're coming to you to say, hey, we saw this fantastic idea. We saw that you have patented it. We can't wait for 20 years when it's going to drop. How can we partner with you? Can we buy this patent from you? Can we buy this patent from you? And trust me, patenting purchase can range from, depending on how valuable you think they need it, can range from $10,000 to $200 million. It just depends on how dire this person needs it. And there are two ways by which we can talk about patenting purchase. They may want to buy you out as a competition, just so that you are not competing with them, or they believe that you have done 60 to 70% of what they need to do, and they just want to leverage on what you're doing, and they say, let's buy you out. We'll take the product, we'll rebrand it, and then we'll run with it. So two ways by which there can be a patent purchase. If you have any question along the line, please feel free to let me know. That's about patenting. Any questions before we go to copyright?
Yes, I have a question. So let's say I have an idea or a method that I'm able to patent here in the US. Is that just for the territory of US, or is it global if I do it here in the
It's
US?
just for the territory of the United States.
Okay.
If you go to the UK, you have to register that invention. Now, the good thing about that is this, I mentioned to you, because you are the owner of that invention, the registration is global.
Okay.
So you may not be able to register it as a patent again in UK because it already exists. But nothing stops you from selling in the UK.
Okay.
If you already have a patent somewhere, I told you that because it's registered in the United States does not mean you are going to the UK to go register it again and call it another patent. No, as long as it exists, it is considered in existence.
Okay.
So, however, you are able to, the patenting not being able to use it is only for the territory of the United States. It's now left for the United Kingdom to want to make sure that they check to see that whatever you are claiming that you want to register is not already existing, because if it does, they should not register it for you as a new patent because it already exists somewhere.
Okay. Thank you.
You're welcome. So copyright is easy because it's about my own idea or my own, how do I say that? So it's an original, artistic, dramatic, literary, or musical work. So, when they say it has a copyright to a music, no one else can. When you're trying to play someone's music for a public event, they will ask you, did you get permission from the owner of the music before you start using it? That does not require any registration. It's just like Sinach sang a song. Now, every other person can choose to sing that song. It's free for all. However, nobody has a right to reproduce that song. You cannot reproduce that song you can play it. And some of the ways by which inventions are copyrighted. So for instance, if SCC is okay, now let me tell you something. You recall that in the last 2 sessions, I talked about, I wanted to play a video. And I said, I didn't want to play the video while our session was already recorded. If I had done that, I would have been infringing on the copyright of the person who produced or who recorded that video. Because what's going to happen is that my own session is recorded. I recorded it with another person's conversation without their approval. And if I choose to post my own video online, including that person's video in it, I have infringed on that person's copyright. And it happens a lot. So SCC wants to do their birthday songs. They are playing songs from, say, anybody. Facebook will usually tell us, you do not have a right to play this music. Why? Because we were streaming our website or our service at the time that we were playing that song. And that is ways by which copyrights are protected. Even though they do not require any registration, you do not have a right to reproduce any copyrighted invention or any copyrighted material. It is against the law. Now, it is often described as the expression of an idea, pictures, photographs, films, books, articles, guides, instructions, sheet music, lyrics, software, subcode, graphical user interface. And you begin to understand. So you should now begin to piece it together why an art will be sold for so much money, and you begin to wonder, does this even look good? What is the aesthetic that you're seeing in this thing that makes you want to pay this much money for it? It's because that particular art cannot be replicated. Work of art can only be original to the extent of the person who did it. And you will find out that they can only, in those cases, there's only one. And it probably has been transferred from generation to generation, and you do not have a right to replicate it. Art, music, nope. The owner, the original owner of that music is the person that has a right to be able to choose who replicates the song. And of course, you will now begin to understand why they say there's remix. You cannot do a remix of a song without the authority or without the approval of the person that sang the song initially. So you can remix a song, but it's by the owner's approval. You can choose to redo a work of art, but one, it's either done by the owner of the original art, or it gives you a right to replicate or reproduce that particular work of art. But when it comes to copywriting, it's not registered, but you do not have a right to replicate it. Copyright scope of protection. It arises automatically. There's no need to register, and it can last up to 70 years, even after the death of the creator. You need to show who, when, and how it was created, and there must be a proof of ownership before you can lay claim on that. Infringement in this case is the unauthorized reproduction of a whole, maybe the entire clip or an entire invention, substantial part of the work in question. That will be an infringement. And of course, you have to show copying has taken place. So if created independently, may not be an infringement, because if this person chooses to create something similar but not exactly, it will not be considered an infringement. But if you replicate it exactly the way it is, without the express authorization of the person who owns it, then you have infringed on that person's right. And of course, you have to be very, very careful of what you copy on the internet, because the internet is for everybody right now, but a lot of people don't understand what it takes to infringe on people's rights and patents or even their copyright. So you have to be careful how you replicate. You have to be careful how you copy, because you may be infringing on someone's right, which is punishable by law. They can sue you for infringing on somebody's invention. So it's critical that you know what to do and what not to do. Any questions on copyright? So, trademarks. This is easier than the remaining two, in the sense that all you're just doing is you're laying claim to that particular image so that no one else can replicate it. I'm sure you must have seen all of these logos before from somewhere. And these are all trademarked. In actual fact, the Roundtable is in the process of being trademarked right now, such that no one else will be able to replicate this image exactly as it is. And same way with Starbucks. Now, you are able to have a trademark and have a patent at the same time. You can choose to have just a trademark only, no patent. But importantly, if you have, so for instance, if anyone decides to use this Nike logo, you'll be infringing on their trademark, because this is only particular to Nike. Now, look at the Coca-Cola bottle. This bottle is patented. The Coca-Cola name is trademarked. So which means everywhere you see this bottle, no one else can have this kind of bottle and call it Fanta.
Yeah.
You cannot have this kind of bottle and call it Crush. This bottle is specifically designed for Coca-Cola. And these are some of the levels by which you can go. When you see this bottle, you already know that this is a bottle of Coca-Cola from year to year. And they also created that name specifically for Coca-Cola and decided to trademark it. Same with Apple, same with Starbucks, same with McDonald's. Any kind of images that you see around. Now, a lot of people may not decide to trademark their logo, but more often than not, major corporations, they trademark their image such that it cannot be reproduced by anyone else in any form or shape to try and want to recreate yours. The moment you do, you are infringing on their property or in their intellectual property. So you have to be careful. And of course, Jade Matthews, if you eventually come up with your own logo and you do not want anyone else to be able to infringe on it, you need to think about trademarking it. And trademark is as cheap as $40 to $125.
Oh, okay. And how long does it take?
That one is also for a period of 20 years.
Okay.
Okay. And of course, so the cost, a patent can cost between $900 for a do-it-yourself application to between $5,000 and $10,000 with the help of patent lawyers. Now, you can appreciate why it will cost about $5,000 to $10,000 if you get someone in. It takes about 4 years worth of work to get this done. In actual fact, if you choose to do it by yourself, it will only cost you about between $900 to $1,000. But because these people have to be on your retainership for the period of that 4 years, until it gets approved. And of course, if it gets kicked back, to say that, oh, we need this document, we need that document, they are there to help you make that happen. That's why they usually charge that much. But if you want to do it by yourself, you are able to do this and at a cost of a $900 to $1,000. Copyright, sorry, I misspoke. Copyright is the one that is $45 to $125, while trademarks is $225 to $600, depending on how long you want it to be. The minimum is 20 years. Some people can do it for as long as 30, 40, 50, 70 years, up until the time you choose. And some people have it in such a way that they just have it till infinity. Coca-Cola logo right now is till infinity. As long as Coca-Cola exists, nobody has a right to replicate that bottle. And it's the same way with a whole lot of product, because maintenance of it, you can just choose, okay, well, this business is here on the long run forever. I don't want to patent it for 2 years. I want to do it for the whole years that it exists ever. And even if I'm not there, that patent or that trademark or that copyright is still there for me to use. The only thing that you are not able to patent beyond 20 years is the only thing you're not able to do beyond 20 years is the patent. Copyright can go for as long as 70 years. And of course, trademark, you can choose to renew it after every 20 years to continue keeping it. Or if you choose that you want to make it an everlasting trademark, it's up to you. It just depends on the kind of money you're going to spend on it. So in a nutshell, that's typical of what it is. And a lot of small businesses may not think about what it is or how important it is to patent or to protect your intellectual property. But you always want to make sure that you have this at the back burner. Should there be a time that you invent your own product or you invent your own method, just so that it will be, that there's something like this that I can do to protect myself or to protect my intellectual property. But at this point, you may not need it, but it's good information to have if that time ever arises. Any questions?
Oh, I don't have any questions. I think it's very informative, and the information will come in handy one day. I'm sure of that.
Absolutely.
Yes.
Absolutely. Okay. Yeah, that's good. That's good. So I'm happy that we're able to run this. Usually what takes a lot of time during the session is because we have a lot of people who want to ask questions and all of that. It's good that also, it's good and bad. We didn't have enough people, but at least it's good that we also didn't have enough people and we're able to wrap up quickly. But this session is recorded. We'll be able to share with everyone who cares to watch it afterwards. We also have our next session, which is going to be about taxes and laws next week, Thursday. And I want to enjoin everyone to ensure that they attend that session because it's critical. This is something that you need to know right now. You don't want to wait. Ignorance is not an excuse when it comes to taxes. So I encourage everyone to ensure that they plan to attend that session next week, Thursday. The two ladies who are going to be taking us through that session, Gia Jones and Kelly Stewart, run a tax service company for the last 21 years. So they know and understand all the intricacies of small businesses and even small business tax and even personal individual taxes as well. So I look forward to everyone joining next week. So just before we wrap up, is there anything any exciting thing that you're looking to do over the next week or so? I usually love to hear the good news when they happen. Anything you want to do or anything you're working on?
Yes, I'll continue working on my website, with Shopify, and I hope that in the next week or two it kicks off fully.
That's good.
Yeah, so that's what I'll be working on. And I'll also try to, I'm not making any promises about social media, but yeah, I'll start looking into that as well.
Okay.
Yeah.
Yeah, there's nothing bad in setting up your social media. You may probably just make sure that you are guided around how you name your social media platforms. I see a lot of people set up their platforms on Facebook. So for instance, we're going to use your name. On Facebook is Jade Matthews Souvenirs. On Instagram is J underscore Matthews. You understand? You want to make sure that you have a consistent name that it will be easier to replicate so that it doesn't confuse your audience. Because trust me, anyone that is looking for your business will look most likely look for Jade Matthews. Now, the
Mhm.
moment there is a dot, a period, or an underscore, or something, some nomenclature that differentiates it from the actual name, you are making yourself difficult for customers to find. Okay.
Yeah.
So want to make sure that if and whenever you're ready to start, and you can start with one.
Mhm.
It could be as easy as Instagram is easier to
Yeah.
get started, right? And once you master your Instagram, you can translate to Facebook. And the good thing about Instagram and Facebook is because they are run by the same company, which is now Meta, because Facebook is the parent company. Once you are posting on Facebook, you are able to instantly post on your, no, sorry, once you are pasting on your Instagram, it gives you the option to post directly into your Facebook account as well. So it will be just one post, but it will have two impacts. And there are so many other ways by which you can leverage your business account, and make sure that when you are setting up your Facebook or your Instagram account, they are business accounts,
Yes.
not individuals, because individuals are limited to the things that they can do. But when it comes to the business account, it also allows you to be able to boost it, which will increase your branding. Now, Facebook, on the other hand, you must make sure that you have a personal Facebook account to start with. Then it is from inside your personal Facebook account that you will now create a page for your business.
Okay.
So you will be able to manage both, but you will not be able to set up a business account without having a personal account first. It's just a way of protecting and ensuring that there are no fictitious accounts. So
Okay.
your personal Facebook is what will allow you to be able to create a page for your business account. And once that is done and they're able to verify it, you are good to go, and you are able to link your Facebook to your Instagram, and of course, all of the other things that you need from there will come easily to you. But I'm very happy with all I'm hearing, Jade. Good job.
Thank you, sir.
I'm so happy for you.
Thank
Of course, feel free to reach out to me if you have any question. If you want to set up a one-on-one,
Okay.
and let's see how we can make each other happy. Okay.
Okay. Okay. Thank you, sir.
You are welcome. This will be the end of the session today. We will reconvene next week, Thursday, same time, 6:30 p.m. Okay.
Okay.
All right. Thank you.